Practical aspects of applying LLM in legal research. Introduction. Large language models, LLMs, are transforming legal research, offering new ways to approach complex legal questions and analyses. This section explores practical aspects of using LLMs in legal research, focusing on effective query formulation and rigorous verification of LLM-generated outputs. By mastering these skills, researchers can harness LLM's power while maintaining high standards of accuracy and critical thinking. The discussion provides insights into crafting effective prompts, optimizing LLM interactions, developing a critical approach to AI-generated content, and integrating LLM outputs into legal research frameworks. Effective prompt engineering. Dear listeners, formulating clear and specific prompts is crucial for maximizing LLM's utility in legal research. Effective prompt engineering requires understanding both LLM capabilities and legal analysis intricacies. Complex legal questions should be broken down into smaller, manageable queries. For example, instead of analyzing the entire doctrine of promissory estoppel, start with its historical development, then separate prompts on elements and application in specific jurisdictions. Use precise legal terminology consistently, mirroring authoritative legal sources. Structure prompts differently for various types of legal analysis. To ensure balanced viewpoints, instruct the LLM to consider multiple perspectives. Context setting in prompts is crucial for more accurate responses, specifying jurisdiction, time period, or area of law. Maximizing LLM potential often requires sophisticated interaction strategies beyond single queries. Prompt chaining guides the LLM through complex legal analysis using interconnected prompts. For example, examining tort law evolution might start with historical developments, followed by key cases and current trends. Use LLM outputs to generate follow-up questions, creating a dynamic research process. Incorporate specific legal sources in prompts to enhance accuracy. Explore counterarguments with prompts like, "What are the main criticisms of this legal theory, and how might proponents respond?" Use LLMs to generate research outlines or plans. For instance, create a detailed outline for a research paper on autonomous vehicles' legal implications, provides a structured starting point for further investigation. Developing a critical approach. While LLMs offer powerful capabilities, developing a critical approach to their outputs is essential for maintaining scholarly integrity. Approach LLM-generated content with healthy skepticism, recognizing potential errors or biases. Cross-reference outputs with authoritative legal sources. Identify potential biases, especially when dealing with topics related to marginalized groups or controversial issues. Assess logical consistency of LLM-provided legal arguments, scrutinizing reasoning for gaps or fallacies. Evaluate output relevance to specific legal questions, discerning truly valuable insights. Be aware of common LLM errors in legal contexts, such as misattributions of legal principles or oversimplification of complex doctrines. Integrating LLM outputs into research. Effective integration of LLM outputs into legal research requires a thoughtful approach. Use LLM-generated insights as starting points for deeper investigation, not final conclusions. Document and cite LLM contributions transparently, noting specific ways LLMs were used. Use LLM-generated ideas to enhance, not replace, critical thinking. Combine LLM assistance with traditional research methods for a synergistic approach. For example, use LLMs to generate initial hypotheses, then rigorously investigate through conventional techniques. Some scholars use LLMs to identify patterns in large legal datasets or generate initial literature review drafts. Ethical considerations in LLM use. LLM use in legal research raises significant ethical considerations. One primary concern is the potential to perpetuate or amplify existing biases in the legal system. Researchers must critically examine LLM-generated content for biases and seek diverse perspectives. Maintain academic integrity when using AI assistance, balancing leveraging AI as a tool with preserving original scholarship. Be transparent about LLM use, clearly delineating between AI-assisted insights and original analysis. Address the potential for LLMs to generate plausible-sounding but factually incorrect information, which could have serious consequences in the legal field. Implications for legal education. LLM integration into legal research has profound implications for legal education. Law schools must adapt curricula to prepare students for a technologically augmented legal landscape. This may involve introducing AI and law courses, focusing on both technical aspects and critical thinking skills. Legal research and writing courses may need to include modules on effective prompt engineering, critical evaluation of LLM outputs, and ethical considerations. LLMs could serve as educational tools, providing interactive learning experiences and personalized feedback. However, educators must balance embracing technological advancements with ensuring fundamental legal reasoning skills are not neglected. Impact on access to justice. LLM application in legal research could significantly impact access to justice. LLMs could democratize access to legal information and analysis, making it easier for individuals without formal legal training to understand complex legal concepts. LLM-powered chatbots could provide basic legal information and guidance. LLMs could assist pro bono lawyers and legal aid organizations in conducting more efficient research. However, reliance on LLMs in legal contexts raises concerns about exacerbating existing inequalities. If advanced LLM tool access becomes a significant advantage, it could widen the gap between well-resourced law firms and underfunded public defenders. There are also concerns about LLMs perpetuating biases present in the legal system, potentially disadvantaging already marginalized groups. Challenges in LLM adoption. Despite potential benefits, LLM adoption in legal research faces significant challenges. The black box nature of many LLM algorithms makes it difficult to understand how models arrive at conclusions, problematic in legal contexts where reasoning explanation is crucial. Ensuring LLM knowledge currency presents challenges, as models are trained on historical data. Maintaining accuracy and reliability in a field where precision is paramount is ongoing. The potential for LLMs to generate convincing but false information is particularly problematic. Data privacy and confidentiality concerns arise when using LLMs for legal research, especially with sensitive client information. Integrating LLMs into existing legal research workflows presents technical and organizational challenges. Future outlook. Ladies and gentlemen, the integration of large language models into legal research methodologies represents a significant advancement with the potential to revolutionize how legal scholars approach complex legal questions. While LLMs offer powerful capabilities for enhancing research efficiency and generating novel insights, their use must be tempered with critical thinking and ethical considerations. The practical aspects of applying LLMs in legal research, from crafting effective prompts to critically evaluating AI-generated outputs, require new skills that legal professionals must develop. As technology evolves, so must strategies for leveraging these tools responsibly and effectively. The future of LLM use in legal research holds exciting possibilities for enhancing access to justice, transforming legal education, and pushing the boundaries of legal analysis, while presenting challenges that must be carefully navigated. Analysis of judicial practice, methods and tools. Introduction. Judicial practice analysis is crucial in legal research, offering insights into the practical application and interpretation of law within real-world contexts. This approach involves comprehensive examination of court decisions, judicial reasoning, and case law trends, providing a nuanced understanding of legal principle operationalization. Its significance extends beyond academic curiosity, shaping legal scholarship, informing practitioner strategies, and guiding policy formulation. As the legal landscape evolves, so do the methods and tools for conducting these analyses, ranging from traditional close reading techniques to cutting-edge technological solutions. This section explores the diverse methodologies and instruments employed in judicial practice analysis, offering an overview of both time-honored approaches and innovative analytical techniques. Significance of judicial practice analysis. Judicial practice analysis bridges abstract legal principles and concrete application, offering insight into legal interpretation and enforcement. It recognizes judicial decisions' pivotal role in shaping law, acknowledging that statutes often find true meaning through judicial exegesis. For instance, Marbury v. Madison, 1803, established judicial review, altering the American legal landscape. Studying judicial behavior reveals decision-making patterns impacting legal outcomes, crucial for practitioners in crafting arguments and anticipating judicial responses. Moreover, this analysis plays a critical role in legal reform efforts, highlighting areas where current laws may be ambiguous, outdated, or inconsistently applied. Dear listeners, traditional methods of judicial practice analysis involve meticulous examination of court opinions. Close reading and annotation of judgments remain indispensable, allowing researchers to dissect judicial reasoning nuances. A critical skill is distinguishing between ratio decidendi, binding principle, and obiter dicta, persuasive comments. Tracing legal principle development through case law often involves creating detailed case chronologies. Comparative analysis of decisions across courts or jurisdictions can reveal divergences or convergences in legal reasoning. Effective case briefing methods, such as IRAC, issue, rule, application, conclusion, provide structured approaches to distilling key information from complex judgments. Quantitative methodologies in analysis. Quantitative methodologies offer powerful insights in judicial practice analysis. Basic statistical methods reveal trends in judicial decision-making, such as case outcome patterns or legal interpretation changes over time. Coding large case sets allows transformation of qualitative data into quantifiable variables, enabling broader pattern recognition. Specialized software facilitates complex analyses, like regression models examining relationships between case characteristics and outcomes. These approaches are valuable in analyzing multi-judge courts, where voting pattern analysis can reveal coalitions or ideological alignments. Techniques for quantifying judicial ideology, like Martin Quinn's scores for U.S. Supreme Court justices, assess judicial preference impact on decision-making. Citation network analysis offers insights into legal precedent influence and interconnectedness. Qualitative approaches offer depth and nuance in understanding judicial reasoning, complementing quantitative methods with rich, contextual insights. Content analysis of judicial opinions allows systematic examination of language, arguments, and reasoning employed by judges. Grounded theory methodology, involving inductive development of theoretical insights from data, can be useful in exploring emerging legal areas. Narrative analysis examines storytelling elements in judgments, recognizing how judges frame facts and issues can influence case outcomes. Analysis of judicial language and rhetoric can reveal subtleties in legal argumentation. Qualitative approaches are valuable in examining contextual factors influencing judicial decisions, such as social, cultural, or political considerations not explicitly stated in judgments. Advanced technological tools. Advanced technological tools have revolutionized judicial practice analysis, offering unprecedented capabilities for processing and analyzing vast legal data. Specialized databases like Westlaw and LexisNexis provide comprehensive case law access, enabling efficient retrieval and analysis. Natural language processing tools have emerged as powerful instruments for analyzing judicial texts at scale, capable of extracting key information, identifying themes, and predicting case outcomes based on textual patterns. Citation analysis tools allow tracking of case law influence over time. Machine learning algorithms have shown promise in predicting judicial outcomes, with some models achieving high accuracy rates in forecasting Supreme Court decisions. Data visualization techniques offer intuitive ways to represent complex legal data and trends. Big data analytics platforms enable processing and analysis of massive judicial decision datasets, identifying patterns and trends imperceptible through traditional methods. Comparative analysis of judicial practices. This slide shows us that the comparative analysis of judicial practices offers rich insight into diverse legal system interpretations and applications across jurisdictions. This approach illuminates unique features of individual systems and reveals universal principles and divergent approaches to common legal challenges. For instance, comparing privacy rights adjudication in the U.S. and EU might reveal fundamental differences in legal philosophy and judicial approach, such as the EU's emphasis on the right to be forgotten versus the U.S. focus on freedom of expression. Techniques for analyzing judicial reasoning differences between legal systems often involve close examination of how courts in different jurisdictions approach similar issues. This might include comparing precedent use, legislative intent weight, or international law consideration in domestic courts. Cross-national studies of judicial behavior can reveal how factors like judicial appointment processes, tenure systems, and legal culture influence decision-making patterns. Ethical considerations in analysis. Judicial practice analysis involves ethical considerations researchers must navigate carefully. Paramount is maintaining judicial independence, ensuring research activities don't unduly influence or appear to influence the judicial process. This is particularly acute when analyzing ongoing or pending cases, balancing knowledge pursuit with respecting legal proceeding integrity. Handling sensitive or confidential court decisions requires strict adherence to ethical guidelines and legal requirements, often necessitating data anonymization or restricted access to findings. Researchers must also address privacy concerns, particularly when analysis involves individual judges or litigants. Maintaining objectivity in controversial judicial decision analysis presents another ethical challenge, requiring researchers to set aside personal biases to present fair, balanced analysis. This is especially crucial when research findings may have public policy or legal reform implications. Integration with other methodologies. Integrating judicial practice analysis with other research methodologies offers a holistic approach to legal scholarship, providing multifaceted insights into legal phenomena. Combining this analysis with doctrinal legal research allows comprehensive understanding of legal principle evolution through judicial interpretation and application. For example, examining promissory estoppel doctrine interpretation might combine close reading of key judgments with broader doctrinal analysis of contract law principles. Empirical studies can complement judicial practice analysis by providing quantitative data on judicial decision real-world impacts. This might involve statistical analysis of case outcomes combined with qualitative analysis of judicial reasoning. Incorporating historical perspectives offers valuable context, illuminating how legal interpretations have evolved over time in response to changing social and political circumstances. Integrating socio-legal approaches can reveal the complex interplay between legal decisions and broader societal factors. Challenges in judicial practice analysis. Despite its invaluable contributions to legal scholarship, judicial practice analysis faces significant challenges. Access to certain court records for decisions, particularly in sensitive cases or lower courts, can be limited, potentially skewing analysis towards readily available high-profile cases. Analyzing unpublished or unreported judicial decisions presents another challenge, as these may contain important legal reasoning not reflected in official reports. Researchers must also contend with inconsistencies in judicial reasoning or practice, complicating efforts to identify clear legal principles or trends. The sheer volume of case law in many jurisdictions poses logistical challenges for comprehensive analysis, necessitating careful sampling strategies or advanced data processing tool use. Generalizing findings from judicial practice analysis requires caution, as specific facts and contexts of individual cases may limit broader applicability of observed patterns. Effective presentation and publication. Effective presentation and publication of judicial practice analysis is crucial for ensuring research findings contribute meaningfully to legal scholarship and practice. Structuring academic papers requires careful organization to guide readers through complex legal concepts and empirical findings. For instance, a paper analyzing constitutional interpretation trends might begin with an overview of relevant constitutional provisions, followed by chronological analysis of key cases, and conclude with observed pattern synthesis and implications. Techniques for presenting complex judicial data clearly often involve visual aids like timelines, charts, or network graphs. Case studies and examples play a vital role in illustrating abstract legal principles or statistical findings, providing concrete instances that make the analysis more accessible and compelling. Balancing quantitative findings with qualitative insights is essential in presenting a comprehensive picture of judicial practice. Methods of legal forecasting and modeling. Introduction. Dear listeners, legal forecasting and modeling represent innovative approaches in legal research, aiming to predict future legal trends, outcomes, and developments within an increasingly complex and rapidly evolving legal landscape. These methodologies have gained significant traction, offering valuable insights for policymaking, legal strategy formulation, and academic research. By employing diverse techniques, ranging from qualitative expert assessments to sophisticated quantitative algorithms, legal forecasting and modeling provide a framework for anticipating legal changes and their potential impacts. This section explores various methods of legal forecasting and modeling, encompassing both qualitative and quantitative approaches, while also addressing their limitations and ethical considerations. Understanding legal forecasting. Legal forecasting encompasses methodologies designed to anticipate future legal developments, trends, and outcomes, serving as a crucial tool for strategic decision-making in legal practice and policy formulation. It aims to provide informed predictions about legal change trajectory, whether in legislative amendments, judicial decisions, or legal doctrine shifts. Its significance lies in enhancing preparedness and adaptability within the legal profession, allowing practitioners and policymakers to proactively address emerging legal challenges. For instance, forecasting techniques have successfully predicted Supreme Court decision likelihood, with models achieving over 70% accuracy in some studies. In regulatory compliance, legal forecasting plays a vital role in risk assessment, enabling organizations to anticipate and prepare for potential regulatory changes. The concept of legal futurism, applying forecasting methodologies to broader legal and societal trends, has gained traction in academic circles, offering a framework for exploring long-term implications of current legal developments. Qualitative approaches to legal forecasting offer rich, context-sensitive insights into potential future legal developments, drawing on expert knowledge and systematic trend analysis. The Delphi technique, a structured communication method, has been effectively employed to harness legal expert collective wisdom. For example, a Delphi study might engage international law experts to forecast climate change litigation trends, iteratively refining predictions through multiple anonymous feedback rounds. Scenario planning involves developing detailed narratives of possible future legal landscapes, particularly valuable in areas of rapid technological change, such as forecasting autonomous vehicle or artificial intelligence legal implications. Trend analysis in legal contexts often involves systematically examining patterns in legislation, case law, and regulatory actions to identify emerging issues and their potential trajectories. Historical analogies provide another valuable tool, allowing researchers to draw insights from past legal developments to inform predictions about future challenges. Quantitative methods in forecasting. Quantitative methods in legal forecasting leverage statistical techniques and computational power to analyze large datasets and identify patterns that may indicate future trends. Time series analysis, a fundamental quantitative forecasting technique, has been applied to various legal indicators, such as case filing rates or specific legal term frequency in court decisions, to project future trends. Regression models have been employed to predict legal outcomes, such as patent litigation success likelihood or potential tort case damages, based on historical data and relevant variables. Machine learning algorithm application in legal forecasting has shown promising results, particularly in predicting court decisions. For example, a study using machine learning techniques to analyze European Court of Human Rights cases achieved a 79% accuracy rate in predicting specific European Convention on Human Rights article violations. Citation network analysis offers insights into potential future influence of legal decisions or scholarly works by examining citation and interconnectedness patterns. Legal modeling techniques offer structured approaches to representing and analyzing complex legal systems and processes, providing valuable tools for both predictive and explanatory research. Conceptual models in law serve to elucidate relationships between legal concepts, actors, and institutions, often providing a foundation for more detailed quantitative or qualitative analyses. For instance, a conceptual model of the legislative process might map interactions between various stakeholders, from initial bill drafting to final enactment. System dynamics modeling has been applied to legal contexts to simulate complex legal system behavior over time, such as modeling sentencing policy impacts on prison populations. Agent-based modeling offers a powerful tool for simulating multiple actor interactions within a legal system, allowing researchers to explore emergent behaviors and outcomes. This approach has been particularly valuable in studying legal rule effects on collective behavior, such as modeling different liability regime impacts on corporate decision-making. Decision trees and influence diagrams provide structured methods for analyzing legal decision-making processes, often used in litigation strategy or regulatory compliance contexts. Game theory models have been employed to analyze strategic interactions in legal settings, such as modeling settlement negotiations or regulatory enforcement strategies. Advanced technological tools. The rapid advancement of technology has ushered in sophisticated tools for legal forecasting and modeling, enhancing researchers' and practitioners' capabilities. Artificial intelligence and machine learning platforms have emerged as powerful engines for legal prediction, capable of processing vast legal data amounts to identify patterns and generate forecasts. For example, AI-powered tools have been developed to predict patent litigation outcomes with high accuracy, analyzing factors such as patent characteristics, litigation history, and judge tendencies. Natural language processing, NLP, technologies play a crucial role in analyzing legal texts for forecasting purposes, enabling automated key information extraction from case law, statutes, and scholarly articles. These NLP tools can identify legal language usage trends, track legal concept evolution, and assess judicial opinion sentiment. Data visualization tools have become indispensable for presenting complex legal forecasts accessibly, with interactive dashboards and dynamic graphs allowing users to explore different scenarios and probabilities. Applications in various legal domains. Legal forecasting methodologies find diverse applications across various law domains, each presenting unique challenges and opportunities for predictive analysis. In legislative forecasting, researchers employ qualitative expert assessments and quantitative voting pattern and political trend analysis to anticipate potential statutory changes. For example, forecasting models have been developed to predict U.S. Congress bill passage likelihood, considering factors such as sponsor influence, committee support, and public opinion. In case law prediction, machine learning algorithms have shown remarkable accuracy in forecasting Supreme Court decisions, analyzing factors such as justice voting history, case characteristics, and broader legal trends. Regulatory forecasting plays a crucial role in compliance planning, with models developed to predict new regulation likelihood and nature in industries such as finance, healthcare, and environmental protection. International legal trend forecasting has become increasingly important in a globalized world, with researchers developing models to predict treaty ratifications, international human rights standard changes, and international dispute resolution trends. Ethical considerations in forecasting. Dear listeners, legal forecasting and modeling technique application raises significant ethical considerations that must be carefully addressed to ensure responsible and equitable use of these powerful tools. A primary concern is predictive models' potential to perpetuate or exacerbate existing legal system biases. For instance, if historical data used to train forecasting algorithms reflect systemic biases in judicial decision-making or law enforcement practices, these biases may be inadvertently encoded into future predictions. Transparency in forecasting methodologies is crucial, not only for scientific validity but also for ethical scrutiny and public trust. Researchers and practitioners must be clear about their models' limitations, assumptions, and potential biases. The responsible use of predictive analytics in legal decision-making requires careful consideration of how these tools might impact justice access and equality before the law. There is a risk that over-reliance on predictive models could lead to a form of algorithmic determinism in legal processes, potentially undermining individual case consideration. Integration with traditional methods. The integration of legal forecasting and modeling with traditional legal research methods offers a powerful approach to comprehensive legal analysis and scholarship. Combining forecasting techniques with doctrinal legal research can provide a forward-looking perspective on legal principles and their potential evolution. For example, a study examining privacy law's future might integrate doctrinal analysis of current privacy statutes and case law with forecasting models predicting potential legislative changes and judicial interpretations. Empirical legal studies can be enhanced by predictive modeling, using historical data to inform future legal trend or outcome projections. This integration is particularly valuable in areas such as criminology, where past crime data statistical analysis can be combined with forecasting models to predict future crime patterns and inform criminal justice policy. Historical analysis plays a crucial role in legal forecasting, providing context and patterns that can inform predictions about future legal developments. Challenges and limitations. While legal forecasting and modeling offer valuable insights, they are subject to significant challenges and limitations that must be acknowledged and addressed. The inherent uncertainty in predicting legal developments stems from the complex interplay of social, political, and economic factors influencing legal change. Unexpected events or paradigm shifts, such as major technological breakthroughs or global crises, can dramatically alter legal landscapes in ways that are difficult to anticipate. Legal systems complexity, with their myriad actors, institutions, and interrelationships, poses significant challenges for accurate modeling and prediction. Limited or biased data can significantly impact legal forecast reliability, particularly in areas where comprehensive historical data is unavailable or existing data reflects systemic biases. Rapidly changing law areas, such as technology regulation or environmental law, present particular challenges for forecasting due to fast-paced developments and potential disruptive changes. Failed legal predictions serve as important reminders of forecasting limitations, such as the widespread failure to anticipate legal and regulatory challenges posed by social media platform rise. Future developments and implications. Legal forecasting and modeling represent innovative and increasingly important methodologies in legal research, offering valuable tools for anticipating future legal developments, trends, and outcomes. These approaches, ranging from qualitative expert assessments to sophisticated quantitative algorithms, provide crucial insights for policymaking, legal strategy formulation, and academic research. By enabling a more proactive and informed approach to legal challenges, forecasting and modeling techniques have the potential to significantly enhance legal system adaptability and effectiveness in an era of rapid change. However, these methods' application must be tempered with a clear understanding of their limitations and ethical implications. The inherent uncertainties in predicting legal developments, potential bias in forecasting models, and challenges in quantifying complex legal phenomena all underscore the need for a cautious and critical approach to legal forecasting. As these methodologies continue to evolve, their integration with traditional legal research methods offers exciting possibilities for comprehensive legal analysis and scholarship. Interdisciplinary approaches in legal research. Introduction. Dear listeners, interdisciplinary approaches in legal research represent a paradigm shift in how legal scholars engage with complex societal issues intersecting with law. These methodologies integrate insights, theories, and methods from diverse academic disciplines to enhance understanding of legal phenomena and their broader implications. The growing importance of interdisciplinary research in addressing multifaceted legal challenges spanning social, economic, and technological domains cannot be overstated. As legal systems grapple with unprecedented global issues, from climate change to artificial intelligence governance, the need for diverse perspectives in legal analysis becomes increasingly apparent. This section explores various interdisciplinary approaches, their applications in legal research, and strategies for effectively integrating diverse disciplinary perspectives. Understanding interdisciplinary legal research. Interdisciplinary legal research represents a methodological approach transcending traditional disciplinary boundaries, integrating perspectives, theories, and methods from multiple academic fields to address complex legal issues. This approach recognizes that many contemporary legal challenges cannot be adequately understood or addressed through a purely doctrinal lens. For instance, law and economics, pioneered by scholars like Richard Posner, has revolutionized understanding of legal rules and institutions by applying economic principles to legal analysis. Similarly, psychological insight integration into legal studies has profoundly impacted areas like jury decision-making and eyewitness testimony reliability. Interdisciplinary approaches offer several key benefits to legal research. They can provide new analytical frameworks for examining legal phenomena, uncover hidden assumptions in legal reasoning, and offer empirical methods for testing legal theories. For example, socio-legal studies have enriched understanding of how law operates in society, moving beyond formal legal texts to examine law's social and cultural contexts. The landscape of interdisciplinary legal research is rich and diverse, encompassing a wide range of methodological approaches blending legal analysis with insights from other academic disciplines. Law and economics, one of the most influential interdisciplinary movements in legal scholarship, applies economic theories and empirical methods to analyze legal rules and institutions. This approach has been particularly impactful in areas such as antitrust law, contract theory, and tort law, where economic efficiency considerations often inform legal decision-making. Law and psychology, another prominent interdisciplinary field, explores legal processes and decision-making psychological dimensions. For instance, research in this area has significantly influenced criminal justice policies, particularly in areas such as eyewitness identification procedures and jury instructions. Sociological approaches to law examine legal institutions and practices' social contexts and impacts, contributing to understanding of law's role in social change and inequality. Anthropological methods have been valuable in studying legal pluralism and indigenous legal systems, offering insights into how different cultures conceptualize and practice law. Methodological approaches. Conducting rigorous interdisciplinary legal research requires careful consideration of methodological approaches that can effectively bridge diverse disciplinary perspectives. One key challenge lies in integrating research methodologies that may have fundamentally different epistemological foundations. For instance, reconciling the normative approach often found in legal scholarship with social sciences empirical methods can require innovative research designs. Developing interdisciplinary research questions is a crucial first step, requiring researchers to identify areas where insights from multiple disciplines can provide a more comprehensive understanding of legal phenomena. For example, a study examining environmental regulation effectiveness might combine legal analysis of statutory frameworks with economic modeling of regulatory impacts and sociological assessment of compliance behaviors. Data collection and analysis in interdisciplinary legal research often involve mixed methods approaches, combining qualitative legal analysis with quantitative empirical methods. This might include integrating doctrinal analysis of case law with statistical analysis of case outcomes or survey data on public perceptions of legal issues. While interdisciplinary approaches offer valuable insights, they also present significant challenges that researchers must navigate. One primary difficulty lies in bridging different disciplinary languages and concepts, as terminologies and theoretical frameworks can vary significantly across fields. For instance, the concept of efficiency may have different connotations in legal scholarship compared to economics, requiring careful definition and contextualization. Accessing and understanding literature from other fields can be daunting for legal scholars, often requiring extensive background reading or collaboration with experts from other disciplines. Potential disciplinary biases or preconceptions can also pose challenges, as researchers must be aware of and address their own disciplinary assumptions when engaging with other fields. Managing diverse theoretical frameworks within a single research project requires a delicate balance, ensuring that different perspectives are integrated coherently rather than merely juxtaposed. Conflicting methodological standards across disciplines can create difficulties in research design and execution, particularly when combining qualitative legal analysis with quantitative empirical methods. Ethical considerations. Interdisciplinary legal research raises unique ethical considerations that researchers must carefully navigate to maintain the integrity and credibility of their work. The application of non-legal methods to legal issues requires thoughtful consideration of the ethical implications, particularly when dealing with sensitive legal topics or vulnerable populations. For instance, employing psychological experiments to study jury decision-making must adhere to both legal ethical standards regarding jury confidentiality and psychological research ethics. Respecting disciplinary ethical standards across multiple fields involved in a research project is crucial, often requiring researchers to navigate potentially conflicting ethical norms. For example, anthropological approaches to studying legal cultures may emphasize participant confidentiality in ways that conflict with legal requirements for disclosure. Maintaining academic integrity in interdisciplinary work involves transparent reporting of methodologies, acknowledgement of limitations, and clear attribution of ideas and data sources from different disciplines. The handling of sensitive data or subjects in cross-disciplinary studies requires careful attention to privacy and consent issues, particularly when legal protections may differ across disciplinary boundaries. Theoretical framework synthesis. The synthesis of theoretical frameworks from diverse disciplines stands as a cornerstone of effective interdisciplinary legal research, offering the potential for novel insights and more comprehensive understanding of complex legal phenomena. This integration process requires researchers to identify complementary theoretical approaches that can illuminate different aspects of a legal issue. For example, combining behavioral economics theories with traditional legal theories of contract formation can provide a more nuanced understanding of how individuals actually engage with contractual agreements. Addressing theoretical conflicts or contradictions between disciplines is a crucial challenge, often requiring researchers to develop new, integrative frameworks that reconcile divergent perspectives. The development of such interdisciplinary theoretical frameworks can lead to groundbreaking legal scholarship, as exemplified by the emergence of critical race theory, which integrates critical legal studies with insights from sociology and ethnic studies. Testing interdisciplinary theories in legal contexts often involves innovative methodological approaches, such as empirical studies that examine how theoretical predictions align with real-world legal outcomes. Tools and resources for research. Ladies and gentlemen, the pursuit of interdisciplinary legal research is facilitated by a growing array of tools and resources designed to support cross-disciplinary inquiry. Specialized databases and search engines for interdisciplinary academic literature, such as JSTOR and Web of Science, provide researchers with access to a broad spectrum of scholarly works across multiple fields. Citation indexes play a crucial role in identifying interdisciplinary connections, allowing researchers to trace idea influence across disciplinary boundaries. For example, Web of Science's cited reference search can reveal how legal concepts have been adopted and adapted in other fields, or how non-legal theories have influenced legal scholarship. Interdisciplinary research networks and collaborations, both formal and informal, offer valuable opportunities for legal scholars to engage with experts from other disciplines. Online platforms like ResearchGate and Academia.edu facilitate interdisciplinary engagement by allowing researchers to share work and connect across traditional disciplinary silos. Data visualization tools have become increasingly important in interdisciplinary legal analysis, enabling researchers to present complex relationships and patterns in accessible formats. Case studies of successful research. Examining successful case studies of interdisciplinary legal research provides valuable insights into the practical application and impact of cross-disciplinary approaches. One notable example is the interdisciplinary study of intellectual property rights in traditional knowledge, which combines legal analysis with anthropological methods to examine how indigenous communities conceptualize and protect their cultural heritage. This research has influenced international policy discussions on expanding intellectual property frameworks to accommodate non-Western knowledge systems. Another impactful case study is the interdisciplinary examination of eyewitness testimony reliability, integrating legal scholarship with cognitive psychology. This work has led to significant reforms in police procedures and judicial instructions regarding eyewitness evidence in many jurisdictions. In the field of environmental law, interdisciplinary research combining legal analysis with climate science and economics has been instrumental in shaping regulatory approaches to climate change mitigation. For instance, studies integrating economic modeling with legal analysis of carbon pricing mechanisms have informed policy debates on the most effective legal instruments for reducing greenhouse gas emissions. Future trends and developments. The landscape of interdisciplinary legal research is poised for significant evolution, driven by emerging technologies, global challenges, and changing academic paradigms. The integration of data science and artificial intelligence with legal research represents a frontier with immense potential. Machine learning algorithms are being developed to analyze vast corpora of legal texts, potentially uncovering patterns and insights that would be impossible to discern through traditional legal analysis alone. The growing importance of STEM fields in legal research is evident in areas such as cybersecurity law, where technical understanding is crucial for developing effective legal frameworks. Emerging interdisciplinary approaches are also addressing global challenges that transcend traditional legal boundaries. For instance, the field of planetary law is evolving to integrate legal principles with Earth systems science to address issues of global environmental governance. The potential for AI and machine learning in interdisciplinary legal analysis extends beyond mere data processing, with some researchers exploring how AI might be used to model complex legal systems or predict policy outcomes. Effective presentation and publishing. Effectively presenting and publishing interdisciplinary legal research requires careful consideration of structure, audience, and publication venues. Structuring interdisciplinary legal research papers often involves a delicate balance between legal analysis and insights from other disciplines. A common approach is to begin with a clear articulation of the legal issue or question, followed by an explanation of how interdisciplinary perspectives can provide new insights or solutions. Presenting complex interdisciplinary findings clearly to diverse audiences is crucial, often requiring researchers to explain concepts and methodologies that may be unfamiliar to legal scholars. For instance, when presenting empirical findings from social science research in a legal context, it's important to explain statistical concepts and their relevance to legal questions. Choosing appropriate journals for interdisciplinary legal work can be challenging, as traditional law reviews may not be equipped to evaluate methodologies from other disciplines. Increasingly, specialized interdisciplinary law journals are emerging as important venues for publishing such research. Balancing legal and non-legal content in publications requires careful attention to the intended audience and publication venue. Selecting and justifying methodology for specific legal research. Introduction. Dear listeners, the selection and justification of appropriate research methodologies are critical components in pursuing rigorous and credible legal scholarship. The chosen methodology significantly influences the research process, shapes finding nature, and ultimately determines the study's overall validity and impact. In the complex legal research landscape, where diverse approaches from doctrinal analysis to empirical investigations coexist, selecting the most suitable methods for specific research questions is both challenging and crucial. This section aims to guide researchers through the intricate process of evaluating different methodological approaches, making informed selections tailored to their research objectives, and effectively justifying these choices. A well-reasoned methodology not only enhances research quality but also demonstrates scholarly rigor, facilitates peer review, and contributes to meaningful academic discourse. Research questions and methodology. The symbiotic relationship between research questions and methodology forms the cornerstone of effective legal research design. Research questions serve as guiding beacons illuminating the path toward appropriate methodological choices, while selected methods, in turn, shape the scope and nature of inquiries that can be meaningfully addressed. For instance, a research question exploring a specific legal doctrine's historical evolution might naturally lead to a methodological approach combining doctrinal analysis with legal history techniques. Conversely, an inquiry into a particular law's practical implementation and social impact would likely necessitate empirical methods, potentially involving surveys, interviews, or statistical analysis of case outcomes. The concept of methodological fit in legal research emphasizes the importance of aligning research methods with not only the questions at hand but also the broader theoretical frameworks and disciplinary traditions within which the research is situated. Researchers must carefully consider the nature of data required to answer their questions effectively, whether it be textual analysis of legal documents, quantitative data on legal outcomes, or qualitative insights into legal processes. The landscape of legal research methodologies is vast and diverse, offering researchers a rich array of approaches to investigate legal phenomena. Traditional doctrinal research, focusing on the systematic analysis of legal rules, principles, and judicial decisions, remains a cornerstone of legal scholarship. This approach is particularly valuable for clarifying legal concepts, tracing legal doctrine development, and critically analyzing legal systems' internal logic. Empirical legal research, encompassing both quantitative and qualitative methods, has gained significant traction in recent decades, offering insights into law's practical operation and societal impacts. Quantitative empirical methods, such as statistical analysis of case outcomes or large-scale surveys, can reveal patterns and trends in legal phenomena that may not be apparent through other approaches. Qualitative empirical methods, including interviews, case studies, and ethnographic research, provide depth and context to legal inquiries, illuminating the lived experiences of legal actors and the nuanced operation of law in society. Comparative legal research methods offer valuable tools for understanding legal phenomena across different jurisdictions or legal systems, contributing to a more global perspective on law. Historical approaches in legal research provide crucial insights into the evolution of legal concepts and institutions, contextualizing contemporary legal issues within broader historical narratives. Evaluating methodological options. The process of evaluating and selecting appropriate methodological options for specific legal research projects requires careful consideration of multiple factors. Researchers must assess the suitability of different methods against their research objectives, the nature of their research questions, and the type of data required to address these questions effectively. For instance, a study aiming to analyze the interpretation of a specific legal statute might primarily employ doctrinal analysis, while an investigation into the effectiveness of a particular legal policy might necessitate empirical methods. Practical constraints, such as time limitations, resource availability, and researcher expertise, play a crucial role in method selection. Evaluating the validity and reliability of different methodological approaches within the context of the specific research project is essential. This may involve pilot testing potential methodologies to assess their feasibility and effectiveness in addressing the research questions at hand. The balance between innovation and established practices in method choice is another critical consideration, as researchers strive to contribute novel insights while maintaining methodological rigor. Justifying methodological choices. The justification of methodological choices is a critical aspect of legal research that enhances the credibility and persuasiveness of scholarly work. A clear and compelling methodological justification not only demonstrates the researcher's thoughtful approach to the study but also provides a foundation for evaluating the validity and reliability of the research findings. In articulating the rationale behind method selection, researchers should explicitly link their chosen methodologies to the specific research questions and objectives of their study. For example, a researcher employing a mixed methods approach to investigate the impact of a new environmental law might justify this choice by explaining how quantitative data on compliance rates will be complemented by qualitative insights into stakeholder perspectives, providing a more comprehensive understanding of the law's effects. Ethical considerations in methodology. Ethical considerations play a pivotal role in the selection and justification of research methodologies in legal studies, reflecting the field's commitment to justice, fairness, and respect for human dignity. Researchers must carefully evaluate the ethical implications of their chosen methods, considering potential risks to participants, issues of confidentiality and privacy, and broader societal impacts of their research. For example, a study involving interviews with victims of domestic violence would require careful ethical consideration regarding participant protection, informed consent, and the potential for re-traumatization. The process of obtaining ethical approval for chosen methods often involves detailed scrutiny by institutional review boards or ethics committees, necessitating clear articulation of the ethical safeguards built into the research design. In comparative or cross-cultural legal research, researchers must be sensitive to diverse cultural norms and legal traditions, ensuring that their methodological approaches are respectful and appropriate across different contexts. Addressing limitations and biases. This slide shows that the acknowledging and addressing methodological limitations and potential biases is a crucial aspect of rigorous legal research, enhancing the credibility and transparency of scholarly work. Researchers must critically examine their chosen methods to identify inherent limitations and potential sources of bias, whether arising from data collection techniques, analytical approaches, or the researcher's own positionality. For instance, a doctrinal analysis of case law might be limited by the selection of cases or jurisdictions examined, while an empirical study using surveys could be affected by response biases or sampling limitations. Strategies for mitigating these limitations often involve careful research design, such as employing multiple methods to triangulate findings or using rigorous sampling techniques to enhance representativeness. Transparency in reporting limitations is essential, allowing readers to assess the scope and applicability of research findings. Adapting methodologies to research contexts. The diverse landscape of legal research necessitates careful adaptation of methodologies to suit specific research contexts and objectives. Doctrinal legal research, focusing on the analysis and interpretation of legal texts, requires methods that emphasize close reading, logical reasoning, and systematic organization of legal principles. For example, a doctrinal analysis of recent Supreme Court decisions on privacy rights might employ techniques of textual interpretation, precedent analysis, and legal theory application. Empirical legal studies, on the other hand, demand methodologies capable of gathering and analyzing data on the practical operation and effects of law in society. This might involve quantitative methods such as statistical analysis of case outcomes, or qualitative approaches like in-depth interviews with legal practitioners. Theoretical legal research often requires methods that facilitate conceptual analysis, theory building, and critical examination of legal paradigms. Integrating multiple methodologies. The integration of multiple methodologies in legal research, often referred to as mixed methods approaches, offers the potential for more comprehensive and nuanced understanding of complex legal phenomena. Combining qualitative and quantitative methods can provide both depth and breadth in legal analysis, offering rich contextual insights alongside broader patterns and trends. For instance, a study on the effectiveness of anti-discrimination laws might combine statistical analysis of case outcomes with in-depth interviews of litigants and judges to provide a multifaceted view of law in action. Integrating empirical and doctrinal methodologies can bridge the gap between law in books and law in practice, offering insights into how legal principles are applied and interpreted in real-world contexts. The sequencing of multiple methods within a research project requires careful planning, considering whether methods will be employed concurrently or sequentially, and how findings from different methodological strands will inform each other. Methodological innovation in legal research. Methodological innovation plays a crucial role in advancing legal scholarship, pushing the boundaries of how legal phenomena are studied and understood. The development of novel research methods in law often involves creative adaptation of approaches from other disciplines or the application of new technologies to legal analysis. For example, the use of network analysis techniques, borrowed from social sciences, has offered new insights into the structure of legal citations and the diffusion of legal ideas. The role of technology in enabling new research methodologies is particularly significant, with computational legal analysis and machine learning techniques opening up possibilities for analyzing vast corpora of legal texts or predicting legal outcomes. Balancing innovation with methodological rigor is essential, requiring researchers to develop robust validation processes for new methods while maintaining the fundamental principles of scientific inquiry. Presenting and defending methodological choices. The effective presentation and defense of methodological choices is crucial for the credibility and impact of legal research. Clearly articulating methodology in research papers involves not only describing the methods used but also explaining the rationale behind these choices and how they align with the research objectives. Structuring the methodology section of legal research articles requires careful consideration of the target audience, balancing the need for detailed methodological explanation with overall readability and engagement. Anticipating and addressing potential methodological critiques in the presentation of research can strengthen the overall argument and demonstrate the researcher's thorough consideration of alternative approaches. When presenting complex methods to diverse audiences, researchers may need to employ analogies, visual aids, or simplified explanations to convey key methodological concepts effectively. Defending methodological choices in academic presentations or during peer review processes requires a combination of thorough preparation, openness to constructive feedback, and the ability to articulate the strengths and limitations of chosen approaches. Thank you for the attention.